Bill 5536.
Good morning, Madam Chair, members of the committee. My name is Kevin Black. I staff the Senate Law and Justice Committee, and you have before you Substitute Senate Bill 5536, sponsored by Senator Robinson, which relates to the state's response to the State versus Blake decision, which is a February 2021 decision of the Washington State Supreme Court, which struck down Washington's statute, which previously made possession of a controlled substance or counterfeit substance a felony offense. In April of 2021, this legislature passed legislation which cured the constitutional defects identified by the Blake decision and reinstated possession of a controlled or counterfeit substance as a misdemeanor offense with an expiration date of July 1st of 2023. Among other provisions, that legislation established a Substance Use Recovery Services Advisory Committee, which I shall call SURSAC, to develop a plan and recommendations which were published in January of this year. What this bill before you does, the substitute bill, it has many provisions, and I'm just going to give you a few highlights. First, it increases the classification of possession of a controlled or counterfeit substance to a gross misdemeanor and removes the expiration date. It establishes a pretrial diversion program for individuals charged with possession of a controlled substance, allowing them to earn dismissal of the charge by meaningfully engaging with substance use disorder treatment. It also enacts provisions addressing 16 recommendations of the SURSAC relating to non-criminal responses to the issue of substance use, including some of the following: expanding opioid treatment programs by removing citing restrictions and directing provision of funding for their expansion around the state, making appropriations for opioid use disorder medication treatment in jails, for expansion of clubhouses, and for establishment of 23-hour crisis relief centers. It provides counsel for parents affected by substance use disorders in certain situations and dependency and child custody cases. It establishes health engagement hubs, which are mobile or fixed site opioid treatment units, which also provide basic health services to people who use drugs. It funds and promotes recovery residences, in part by establishing a real and personal property tax exemption. It provides trainings for parents and children with substance use disorders and for staff at the Department of Children, Youth, and Families. And it also adds work groups, creates work groups at the Healthcare Authority to streamline substance use disorder treatment intakes and establish a safe supply work group, among a number of other provisions. And I will turn it over to Corbin to describe the fiscal impact of those provisions.
There's a partial preliminary fiscal note on the proposed substitute available in your EBB. Where fiscal information is not available in that current fiscal note, I have pulled impacts from the fiscal note on the original bill, as well as estimates from impacted agencies. Overall, the bill has three primary cost drivers. First, the local government impact of the possession standard and the creation of a pretrial diversion program. Secondly, the state impact of the treatment programs in the bill. And thirdly, and finally, the three appropriations contained in the bill. I'll walk through each of these cost drivers at a high level. In terms of local impact, the Administrative Office of the Courts prepared a fiscal note on behalf of courts of limited jurisdiction related to local funding. The AOC note estimates that 12,000 additional cases would be heard in district and municipal courts rather than superior courts each year as a result of the misdemeanor standard in the bill, and that each case would require 3 additional hearings as the person facing charges considers diversion. This is estimated by AOC at a local cost of $5.7 million per year. For the pretrial diversion program, AOC assumes that half of those 12,000 cases would result in diversion, using the average cost of a therapeutic court at $340,000 a year and a court caseload of 120 cases annually. The AOC estimated cost to provide these services is $17 million a year in local impact. In terms of state impact, the bill creates several substance use disorder treatment programs and initiatives. Part 4 of the bill expands access to opioid treatment and expansion, and creates a capital grant program at the Department of Commerce to fund construction costs for SUD, substance use disorder treatment programs. This program would be subject to appropriation in the capital budget, which does currently fund a similar behavioral health community capacity grant program at Commerce. Part 6 of the bill requires that, subject to funding, the Healthcare Authority must make recovery residences available in each region of the state through including the expansion of their revolving fund program for recovery residences. There's an existing revolving fund grant program at the Healthcare Authority, and it is currently funded through a federal grant. This section, as Kevin mentioned, also contains a property tax exemption for real and personal property used by a nonprofit in maintaining a recovery residence. The revenue impact from this exemption is a property tax shift from the state of $198,000 in fiscal year 24 and $390,000 in fiscal year 25 and ongoing, in addition to DOR administrative costs. Part 7 of the bill requires the Healthcare Authority and the Department of Children, Youth, and Families to develop a training for parents of children and youth with substance use disorders and to make available opioid overdose reversal medication to caseworkers and employees. The Department of Children, Youth, and Families estimates the cost to provide reversal medication to be $4.6 million in general fund state over 4 years. That estimate is based on providing 1 kit a month to 1,500 employees. That would be subject to the provisions of that section. Part 9 of the bill requires the Healthcare Authority to develop health engagement hubs, which, as Kevin mentioned, are defined as mobile or fixed site medication units that provide access to medications, care, and harm reduction services. The Healthcare Authority is directed to make funding available to ensure that a hub is available within a 2-hour drive for all communities, and that there is at least 1 health engagement hub available per 200,000 residents in Washington. The 2-hour analysis standard has not yet been completed, but based upon the population standard, this would require 39 health engagement hubs in the state. The cost for this requirement is indeterminate and not yet reflected in the fiscal note before you, but the Healthcare Authority did provide an estimated cost of $1 to $2 million in startup funding per health engagement hub to establish a fixed site location. The governor's proposed budget does provide $6.7 million for hubs out of opioid settlement funding. In addition to the startup costs, Medicaid service cost impacts of expanded health hubs will be indeterminate to the extent that this program drives increased Medicaid utilization. The bill also creates a safe supply work group, requires a WISIP study, and creates an inventory of diversion and recovery services. Each of those will generate a fiscal impact for staffing in affected agencies that aren't yet available in the fiscal note before you today. Finally, the bill contains appropriations in Part 12. The bill appropriates $35 million to expand access to medications for opioid use disorder in jails. It appropriates $7 million for grants to clubhouse programs throughout the state, and $3 million to provide grants, startup grants for 23-hour crisis relief centers statewide. And with that, we're happy to take any questions.
There have got to be questions. Anybody? Okay, I have a couple. Corbin, you mentioned medication in jail. Is that overdose medication or kind of substance use treatment medication?
I believe the standard is called, commonly abbreviated MOUD, or Medications for Opioid Use Disorder. These are services that would traditionally be provided in an opioid treatment program for individuals with opioid addiction specifically. Okay. All right, wait, we got more. I gave people a little time. Senator Mullet.
Oh, there we go. Thank you, Madam Chair. I was keeping track of the numbers in my head of the annual cost, but then at the end it was kind of like at the Mariners game where the hats go really fast. I lost you. Do you have a number written down there if you were to add up what we think are, because I was getting up towards like 25 and then it was 30 million a year and then I kind of lost at the end flurry there.
Yeah, thank you, Senator. I was hoping to be able to provide that this morning. Unfortunately, we don't have sort of determinate impacts across all agencies, but I can follow up with the committee first with what we do have right now, and secondly, when that final fiscal note does come in, I'll make sure that the committee has sort of a final roll-up of the fiscal impact.
Okay, thanks.
Senator Dingra, and then Senator Warnick, and then Senator Billig.
Chair Rolfes, I actually have additional information to provide and sort of a question. Is that okay?
Yes.
So the MOUD program in the jails was started a few years ago, and currently we do that for 19
We
of our-
can't, Senator Dingra, do you have your microphone on?
I do. Is it not working? Oh.
Better, yeah.
So I can't look at you while I'm talking. So we started the MOUDs in jails a few years ago, and 19 of our jails currently provide MOUD services. The plan is to make sure all 59 are actually doing it, and So that's been a very effective program. And the other comment I'll make on the fiscal note is that there's a lot of braiding involved in this. So there are federal dollars, state dollars, Medicaid dollars, lawsuit settlement dollars. And so I just wanted the whole body to know that it is a complex, complicated fiscal note on this bill. Thank you.
Thank you. Senator Warnick?
Thank you, Madam Chair, and that complicated fiscal note is what I'm confused about. How much approximately will be going to the local courts, district courts? Do you have that? Because there will be additional responsibility for them?
Yes, Senator, there are fiscal notes identified for those local court costs in the bill. Any amount that would go towards those costs would be subject to funding in the budget. The Administrative Office of the Courts component of the fiscal note does reflect those local costs at $5.7 million per year for increased caseload and $17 million per fiscal year in terms of the pretrial diversion program that the bill creates. But any funding for those programs from the state would need to be appropriated in the budget.
Thank you.
Senator Billig?
Thank you, Madam Chair. So I'm interested in that point after somebody sort of elects the treatment off-ramp, and then they need to get an assessment. And so you mentioned the health hubs. I see in the bill report about recovery navigators. Is one or both of those for that moment when they get the assessment? And then is that cost going to be part of the fiscal note of what it'll cost all the local governments to do that assessment?
Yeah, I don't think so. No, the programs you mentioned would be for people in the community before they get pulled into the criminal justice system. I think the cost of the substance use assessment would be rolled up in what?
I'm assuming that would come from the pretrial diversion program costs. I don't believe the fiscal note indicates any state costs related specifically to that pretrial diversion program.
And it doesn't indicate it because it's not there yet, or it's not in specific enough in the bill to drive that?
I don't believe there would be a state impact, a determinate state impact from the pretrial diversion program.
Okay, thank you.
Senator Wagner?
Thank you, Madam Chair. So if someone elects this and they're offered treatment, but we don't have the people to provide that treatment, is there a time period for that they get to wait, or what if the service isn't available? We're saying, here, do this. This is a good thing for yourself, but we know that we have a workforce shortage.
Thank you for the question, Senator. And for the record, Joe McKittrick, Staff Counsel to the Law and Justice Committee.
Joe, you know what? The vice chair just pointed out we hadn't heard the criminal part of this because you haven't briefed us yet. So could you?
Actually, Kevin Black did touch on the criminal aspects, but I could briefly go over them again.
Sure, why don't you address Senator Wagner's question and then let's hear what you were planning on telling us.
So Senator Wagner, the bill does not have a time component for specifically related to the pretrial diversion program. That would be an issue that would need to be addressed by the court. And if a person opts into the pretrial diversion program and cannot get treatment, that would be factored into whether or not the court can sanction that person for noncompliance with the program or terminate them from that program. And so that would be a decision that the court, the prosecutor, and defense would need to have conversations about and potentially hearings over. Whether or not there's a true issue with access to treatment or whether or not it's just the client perseverating or just trying not to comply and waste the court's time. Madam Chair, going back to the criminal aspects of this bill would raise the criminal classification of possession of a controlled substance and possession of a counterfeit substance from a gross misdemeanor to, from a misdemeanor to a gross misdemeanor, meaning that it could be punished by up to 364 days in jail, a $5,000 fine, or both a fine and jail. This bill would leave possession of a legend drug and possession of over an ounce of cannabis for a person over 21 or any amount of cannabis for a person under 21 as misdemeanor crimes, meaning that they could be punished by up to 90 days in jail, a $1,000 fine, or both jail and a fine.
All right, well, that seemed to silence us. Senator Hasegawa, did you have a question?
Yeah, thanks, Madam Chair. That's actually the part that I had a question on. The distinguishing between what qualifies as a misdemeanor versus a gross demeanor offense, because I understand that there has to be incentive to drive people to want to choose the alternatives, treatment alternatives, but is there any science around the effectiveness of the gross misdemeanor versus the misdemeanor, how much more effective that may be as a incentive to go towards treatment?
Senator, I have not seen any peer-reviewed articles that factor in whether or not it's a misdemeanor versus a gross misdemeanor. I can say that from my personal experience as a public defender in court, having a gross misdemeanor means the court has a little bit more breathing room to handle cases. The jurisdiction of probation for a gross misdemeanor is 2 years compared to 1 year on a misdemeanor. Likewise, the court has generally what you'll see in misdemeanors and gross misdemeanors is the court will sentence someone and suspend the majority of the sentence. So they'll sentence them on a gross misdemeanor to 364 days in jail and suspend all of that time and then put the person on probation. And if that person fails on something, one of the conditions of probation, then they use that suspended sentence as a sanction for those violations of probation. So having that gross misdemeanor status of counterfeit substances and controlled substances allows that court that 2 years to evaluate this person's progress and potentially sanction them by sending them back to jail for what could amount to a more extensive period of time than with a misdemeanor. I hope that answers your question.
Do you have a follow-up, Bob?
I think I have to process that information because it's a pretty, this whole thing is so complicated, right? But I guess what I'm curious of originally was that is there any actual science behind the thing? And that question has been answered. There's not really peer-reviewed studies on this. So.
No, when most of the articles that I've read about the punishment aspect as a deterrence to drug use is the immediacy of that deterrence or that punishment. So the longer between the behavior that you want to change and the punishment for that change or that behavior, the less effective it will be. And so as the quicker that you can get someone into a treatment program and facing those potential sanctions, the more likely they're going to stick. So I don't know if the severity of the punishment is as effective as the immediacy of that punishment.
I do have
One last follow-up.
Thank you, Madam Chair. So part of the alternative treatment process is reentry, and I was just wondering if there's any evidence of more difficulty in finding good employment or other reentry supports between a misdemeanor and a gross misdemeanor. How does an employer view that? I don't know if you can actually answer that, but.
There's no scientific studies on that, Senator.
We do have somebody testifying from the therapeutic courts, and maybe somebody here could, maybe one of the three of you could address to Senator Hasegawa's question how that system works in terms of dropping the record. The vacation. The vacation.
Yeah, are you speaking specifically in the bill, or?
Just in general, how does the whole system work?
So there's lots of different diversion programs currently. So we currently there's things like drug court, veterans court, mental health court, therapeutic alternatives to prosecution. Oftentimes these come at different stages in the criminal prosecution. So for instance, a therapeutic alternative to prosecution is generally a prosecutor-run program. It's run out of the office of the prosecutor, and it is entry into that program is controlled by the prosecutor's office. If a person is entered into that program, then essentially they have conditions that they must comply with, such as getting treatment, doing community service, making sure they have employment or are in school, and after a period of time in compliance with that program, then the prosecutor's office will agree to dismiss the charge. So no conviction would be on their record generally. Similar in drug courts and veterans courts, a charge is filed. An agreement happens between the prosecutor and the defense to ask the courts to move this case into that alternative court process. The person goes to that court process. There's multiple hearings. Generally, it starts off with at least once a week. Then as the person progresses through the program, that drops down to twice a month, then once a month, and then they finally graduate that program, again getting that charge dismissed. In the bill in front of you today, 5536, there is an option for individuals who have been convicted of possession to then, subsequent to the conviction, seek treatment, and if they meaningfully engage with that treatment and file proof of that meaningful engagement with the court can then go back and vacate that conviction. And I know hasn't been studies on whether a misdemeanor versus a gross misdemeanor has disparate impacts on someone's employment opportunities. I think it's safe to say that having a conviction for possession of controlled substances on your criminal record is a barrier to getting a lot of jobs, especially a lot of low entry or entry level positions. And so I think that this bill contemplates multiple avenues for individuals to seek treatment, take responsibility for their actions, and with the incentive of not having a conviction on their record.
Thank you. Senator Benke and then Senator Conway. And I want to say I'm usually rush this committee along, but this bill is really important for us to get right. And since this is almost half the Senate, it's a good opportunity for members to understand and try to help find a path forward. Senator Benke.
Thank you, Madam Chair. Mine goes to the data support. You talk about developing a data integration platform. Is that going into our data privacy of the individuals throughout this process, or can you speak to some of the data privacy? Because it says it's going to be platform by 2024, and so it's pretty quick to develop a platform like that without looking into the details of what the data is and how that's being collected and shared throughout the process. Can you speak to that?
So the data platform is supposed to support the work of recovery navigators, which was part of what was established 2 years ago in the first Blake bill. As far as the timeline, I think the agency would be better to speak to whether the timeline is sufficient to do the work. I know that privacy is one of the considerations in the being considered.
All right, anybody else? Oh, Senator Conway.
I guess, this is a critical issue for the legislative session. Do we have data? Do we have data on the issue of people who've been referred to treatment, completed their treatment under our current law? And I'm just curious whether or not, that kind of goes at Senator Hasagawa's issue here, whether the issue of the kind of punishment is enough to drive people into treatment. Frankly, the data I've been hearing anecdotally is that people have not been going into treatment. And I'm just wondering if we have any data on, since we passed the law, on that issue. Thank you.
So, Senator Conway, there's a lot of data that we can get for you if you're specific about what you're looking for. Certainly participation in statewide treatment, rates of completion of that treatment, I think is things that are tracked by the healthcare authority. I'd be happy to follow up with you about, specific requests.
Let's get that for the whole committee when you nail down what the request is. Okay. I have one question for Corbin, or actually for any of you. Has there been any discussion about whether the toxicology lab is needed for this bill? I don't know a lot about how the whole system works, but I don't see any fiscal note for the State Patrol.
I'll have to look into that and get back to you. I don't remember off the top of my head if the State Patrol has a determinate impact in the note.
Okay, thank you. Okay, another question, Senator Hasegawa.
Thank you, Madam Chair. Just on that information request, I would also, if you have the data, like to see a comparison of just the threat of the charge being filed as opposed to the actual going through that process. The threat of the charge being filed being enough motivation to drive somebody to choose alternative treatment plans as opposed to a charge being filed having gone through the court process. I mean, the fiscal note is pretty large just to go into the process and push people through that process to make that threat.
So it sounds like you're asking about participation in therapeutic drug courts around the state. That's going to be difficult because it's decentralized. That's not a state operated, that's a series of programs run in local jurisdictions around the state. I think most of those programs are full, and the constraint has been slots.
Yeah, the reason that I'm asking for this is because it's not just the conviction, I think, of the crime that's a barrier in the future pathway of a person to reintegrate, but the charge itself being filed is a barrier itself that employers also look at. So I was hoping that maybe there's a way to get some data to see whether or not just the threat of a charge as opposed to actual conviction of the gross misdemeanor or the misdemeanor is actually a sufficient threat.
Be happy
Does that
to
make
follow.
sense?
I'm not sure for data you need something to count. I'm not sure what we would be counting, but I'm happy to follow up with you, Senator Hasegawa, to figure this out.
Okay, because the reason that I'm asking is that under the current law, my understanding is that there was not even the threat of conviction. They couldn't even threaten to convict until after the second offense or something like that. And part of the problem had been there's no tracking between jurisdictions so that people get, what would you say, caught by the police in one jurisdiction, but that doesn't count if it's subsequently caught in a different jurisdiction and there was no way to track when the second offense was. And
Senator, I can answer that question for you. So the specific statute you're referring to is RCW 1031-115, which required officers to take individuals who would otherwise be subject to arrest for possession and defer them to services and treatment for the first 2 times that person has an interaction with law enforcement. The issue became that when no charges were filed, there was no cross law enforcement agency tracking of those interactions. So if someone was arrested in Seattle, that would not be communicated if that same person was arrested in Everett. In this bill, it repeals that law, and into the relevant possession statutes, it provides an encouragement rather than a requirement for law enforcement to utilize pre-charging diversion programs such as the Law Enforcement Assisted Diversion Program and other programs that would get to the treatment aspect prior to any charges being filed. So I hope that helps answer your question.
Okay, this will be our last question. Senator Wagner.
Thank you, Madam Chair. What is the feedback loop to the court? Is that done through the navigators, the success or failure of the diversion program? How does that get back to the court?
So that would be provided by the treatment program, whichever treatment program the individual opts into. The bill does not specify specific treatment programs that any individual needs to use if they're in the pretrial diversion. They have that option. I think that becomes complicated by what type of insurance they have, where they're located, the requirements of the specific treatment that they need. But that is a system that I believe that most treatment providers in the state currently do. Oftentimes when you see a misdemeanor conviction that's drug-related, as a condition of probation, that person will generally have treatment required by the court. And so these treatment program providers are generally capable and well-versed in providing this information to the courts and prosecutors when there's any violations or non-compliance with treatment.
Corbin?
I can just quickly answer your question, Senator, around impacts to the crime lab from the fiscal note. The State Patrol indicates an indeterminate impact in their fiscal note. They mentioned that it is possible that the State Patrol could see significant increases in requests for related evidence analysis, but also there's a potential for those requests to decrease given the emphasis of the proposed legislation on pretrial intervention. So if more individuals are sort of intervened before that court goes to hearing, the impact to the crime lab could be reduced.
Okay, I would like to ask for follow-up on what the backlog is at the crime lab, like how long it takes to get stuff processed.
Yeah, we can look into that and get back to you.
Thank you. All right, Senator Robinson, would you like to briefly speak to your bill?
Madam Chair, there's been a very robust discussion here, so I don't want to speak actually to the bill. I just want to say that for anyone who has specific changes they would like to see in the bill, please get them to me and staff or just to me in writing by close of business Monday so that we can work to improve this bill as we move it out of this committee later in the week. Thank you.
Thank you. All right, we have about 30 people signed in to testify. I'm going to call up the first three that are signed up in person: Bob Cooper, Candace Bach, and Ann Anderson. And while they're making their way up, I'd like to ask Scott Brandon, Dana Ralph, Armando Pavone, and Caleb Banta Green to be ready. And I don't see Bob Cooper. So
I am here.
Oh, you're online. Go ahead. Go ahead, Bob.
Thank you, Madam Chair and members of the committee. For the record, Bob Cooper here on behalf of the Washington Association of Drug Courts. And specific to this bill and even outside of this bill, I'm here to emphasize that the last word in the description, the short description on your bill report, is vital to making this happen, and that's treatment. You have to fund treatment. You have to fund drug courts through the Criminal Justice Treatment Account and fully appropriate that. The governor's budget has $21 million for courts of limited jurisdiction for those gross misdemeanor charges. You have to have treatment available on demand across the state. It has to be just as available in Hump Tulips as it is in downtown Seattle. It has to be immediate, as staff pointed out. The faster that process gets going, the better off you are. And in answer to a question that I did here, drug courts have a very high success of reducing recidivism, about a 70% or better success rate. So therapeutic courts do work, but you have to fund them, and you have to fund associated treatment that would be outside of this bill and into the budget.
Thank you.
Be happy to answer any questions.
Thank you. I think you answered Senator Hasagawa, one of Senator Hasagawa's questions. If you have any evidence-based research on drug courts, I think the members of the committee would appreciate it, so send that along, if you have it.
There is information from a couple of WISP studies, and I will send that along.
Thank you. Scott Brandon.
My name is Scott Brandon. I'm the Executive Director of Olympic Peninsula Community Clinic in Port Angeles. We operate the Rediscovery Program, which includes an Arrest and Jail Alternatives, or AJA program, funded by WASPIC, and a LEAD program I'm here today to express support for key aspects of Senate Bill 5536, not on behalf of WASPIC, LEAD, or any other affiliated program, funder, or sponsor, but on behalf of OPCC and the population that we serve. In Clallam County, we have one of the highest overdose per capita rates in the state. Reframing our approach to certain drug crimes will provide additional opportunities for programs like ours to provide effective, cost-effective services to individuals pre-arrest. My organization primarily serves members of our community who face challenges accessing traditional services, and many, if not most of the people we serve, suffer from addiction and or mental health issues and have frequent interactions with the criminal justice system. The programs that we operate work. LEAD and AJA programs are mentioned specifically in this bill, but there's no additional funding or investment in the program, so I respectfully recommend and request that significant additional funding be provided for LEAD and AJA programs distinctly and separately from Recovery Navigator programs in order to maintain the existing LEAD and AJA programs and expand their use across the state. And I also have data to support some of the questions from Senator Conway, Senator Hasegawa, and others.
We will look forward to receiving that. Thank you very much for participating this morning. Have a great weekend. Dana Ralph.
Good morning, Chair Rolfes, Ranking Member Wilson, and committee members. My name is Dana Ralph, and I'm the mayor for the city of Kent, and I want to say thank you for this opportunity to testify virtually on Senate Bill 5536. While the bill before you will require significant investment from the state, addressing the possession of controlled substances is hands down the most important thing you can tackle this session. It is at the top of the list of concerns that I hear from my residents every single day, and without your action, the impacts will only continue to grow. Senate Bill 5536 includes an option for pretrial diversion for a gross misdemeanor. This pretrial program will be housed within our municipal courts, and as such, we do ask that you allocate funding to cities to stand up and manage these pretrial diversion programs. We also urge that you consider the resources needed for prosecution. If an individual chooses pretrial treatment and doesn't complete that treatment, the case will then be prosecuted, but at a much later date. And prosecution after treatment will likely require more time and resources than our current model that we're using with our DUI court, where prosecution occurs earlier in the process. Finally, there are several investments targeted at opioid treatment. We'd encourage you to make these investments flexible so that we can also obtain treatment for individuals suffering from methamphetamine use. It's a really important part of the drug issues that we are seeing in our communities. Again, thank you for the opportunity to testify and the very robust conversation this morning. It was very heartening to hear all of the questions and the thought going into this process.
Thank you very much, Mayor. And we have another mayor, Armando Pavone from Renton.
Good morning, I'm Renton Mayor Armando Pavone. I want to thank you for the opportunity to speak to you today. In a recent emphasis patrol of our downtown, Renton police officers made outreach to 350 people experiencing homelessness and addiction. Less than 10 were open to a treatment referral. That's just 2.8%. We don't know if any of them met with the provider. There's just no follow-up. This often results in those suffering from addiction refusing treatment and ultimately leaving them in the safe, often unsafe environment. These incidences and many others have led to a significant spike in public police calls, police response to open drug, and an often overwhelming increase in complaints from our community members. We need to support our communities that do not want ongoing daily but treatable problems outside their homes. But let's be clear. The people using these substances are sick and deserve support. I and the City Council believe that providing sufficient resources to assist individuals in need is critical to the ultimate success of this effort. Likewise, we support actions to ensure individuals take advantage of the available treatment and that their key is to working through accountability for our court systems. We support deferral of any sentence for offenders who enter a court-approved treatment program. For those people who complete the court requirements, they deserve to have convictions of the offense removed from their record. Therefore, we support the efforts of Bill 5536, the necessary investments to this effort, making them necessary efforts to make this successful, knowing there's more work to be done. Thank you for allowing me to testify today.
And thank you, Mr. Mayor. Candace Bach. Your mayors have spoken.
My mayors have spoken. Thank you, Chair, members of the committee. Candace Bach, representing the Association of Washington Cities. I following the lead of the mayors, will not belabor this, but you've heard from them. We are here in strong support of this bill and this approach, but it does require investments, and we are looking forward to working with you on ensuring that the new responsibilities that cities will be taking on and the expanded responsibilities are funded as you continue your budget deliberations. You heard some of the numbers in the fiscal note. I just want to give you a couple of examples. In Seattle, the LEAD program costs about $6,000 to $11,000 per individual that goes through it. In Walla Walla, they have a LEAD program. They have a budget, an annual budget of about $420,000. So those are programs that will need to expand. Not every community has those kinds of programs available right now. So we'll be looking to you for assistance in that, as well as those court costs that were mentioned. And again, the importance of funding treatment throughout the state, as you heard the mayors say. So we look forward to working with you to ensure that we can successfully implement this bill. Thank you.
Thank you, Candace. Kayla Banta-Green. While we're waiting for Caleb to maybe unmute, I want to make sure that Nancy Bacchus, Vanessa Martin, Michael Held, and Todd Morrell are ready to go. Caleb, are you with us?
I am. Good morning. I'm Caleb Banta-Green. I'm a professor in the School of Medicine and a longtime researcher at the Addictions, Drug, and Alcohol Institute. Among other work, my group provides implementation support and evaluation for substance use, health, and treatment services across the state. I was appointed to the CIRSA committee and served as the co-chair of the treatment subcommittee. Taken together, the CIRSA recommendations incorporated in this bill could dramatically increase accessibility and desirability of substance use, health, and treatment services across the state. People will be much more likely to self-refer to services, and first responders will want to take people to these new services. Health engagement hubs specifically are our best tool to address the crises of fentanyl and methamphetamine addiction and deaths, and we want to make them available to everyone who needs them when, where, and how they want to access them. Opioid use disorder treatment medications are proven to support recovery and reduce mortality by 50%. We've shown that 80% of people with opioid addiction want to stop or reduce their use, and they will access easily accessible care. They do not need legal coercion, threats, nudges, nor sticks to engage in care. Taken together, the CIRSA recommendations could dramatically transform our communities and improve health. I'm happy to provide any further data the committee needs. Thank you.
Thank you very much. Hopefully our staff has connection to you in their search for data. They may reach out. Thank you. Yeah. Nancy Bacchus. Nancy Bacchus.
Thank you. Good morning, Chair Rolfes, Ranking Member Wilson, and committee members. I am Nancy Bacchus, Mayor for the City of Auburn, and I appreciate the opportunity to testify today in support of Substitute Senate Bill 5536. There are three words that I try to use in every decision that I make for our city: compassion, accountability, and community. And I believe those same three words are encompassed in this bill. The compassion is obvious with the requirement of pretrial treatment. The accountability is the increased consequences for knowing possession of a controlled substance to a gross misdemeanor if treatment isn't chosen. And the community is evident throughout the bill to restore safety across our state. I realize this is going to push more responsibility onto the municipal courts and will require significant investment from the state, but this is some of the most important legislation you will take this session. At the local level, there will be a need for more prosecutors, public defenders, and treatment resources. We must work together for the good of those we serve. Please ensure the funding for a successful program. Your community, my community, and lives depend on it. Thank you for your time and your leadership.
Thank you, Mayor. Vanessa, let's see, Ann Anderson.
Thank you. Good morning. Ann Anderson, Washington State Narcotics Investigators Association. We're grateful you are committed to addressing the Blake decision. As written, particularly with new revisions, Substitute Senate Bill 5536 has concerning focus on accommodating drug use rather than on preventing it or protecting those impacted by it, including children who are the victims of their parents' drug use. Not only is this unjust for those whose safety and communities are being sacrificed, it's cruel to continue to enable those who are abusing drugs. Getting people into treatment is crucial. A bill such as 5467 with a deferred sentence rather than pretrial diversion is a better mechanism by which to encourage treatment. All Washingtonians are affected by the growing drug problem. We've seen what happens with ineffective policy. Oregon saw a 700% increase in drug overdose deaths and enormous increases in weapons trafficking and human trafficking. With permissive drug laws come increases in gun crimes, exploitation, and despair. Responsible policy will simultaneously encourage treatment, hold people accountable, and protect our communities. We encourage a substitute bill with a policy that more closely aligns with that in bipartisan 5467 with a deferred sentence pending participation in treatment. Thank you for your consideration. We recognize the complexities of this issue and appreciate the work you're doing.
Thank you. Next up is Vanessa Martin.
Good morning, Madam Chair and committee members. My name is Vanessa Martin. I'm a member of the Whatcom County Lead Leadership Team. I'm here in support of essential aspects of Senate Bill 5536, which reframes our response to certain drug crimes. In Whatcom County, our local law enforcement, prosecutors, public defense, and our broader community members and partners respect and believe in LEAD's approach to health, safety, and equity. Within 2 years, 242 individuals have received long-term community-based care through Whatcom LEAD, and the outcomes have been transformational. The unwavering commitment to LEAD's evidence-based principles has provided an effective and critical resource in response to our community needs. The scale of the drug problems in our communities are vast, and the courts won't be able to tackle more than a small fraction. I am thankful to see substitute bill names LEAD and AJA, arrest and jail alternative programs, as pre-booking diversion frameworks. I just recommend the committee make new investments in LEAD and AJA programs in order to scale up existing programs and expand across jurisdictions. Thank you for the opportunity to testify before you today.
Thank you. Lisa Dogard. Oh, I'm sorry. Lisa and Malika Lamont, please come forward. I didn't mean to put you on the spot. Sorry about that. While they're getting settled, let's hear from Michael Held and then Todd Morrell.
Good morning. My name is Michael Held. I am the Chief of Staff of the Snohomish County Prosecuting Attorney's Office. As we all know, drug addiction and unrelated and untreated mental health disorders are often the root cause of unlawful criminal conduct that carries with it significant other economic and societal harm. Conventional wisdom dictates that addressing these root causes proportionately reduces those harms to our communities. The courts, of course, are critical to doing this important work, but alternative programming is equally essential and in certain cases are and will continue to be a more effective tool in addressing the many complex needs of this offender population. Among the many hats I wear, one is providing the fiscal and programmatic oversight for Snohomish County's successful law enforcement assisted diversion and recovery navigator programs. These, as you probably know, are both state and federally funded intensive and lighter touch pre-booking diversion management programs for low-level offenders who have a history of repeated contacts with the criminal justice system and who are experiencing homelessness. The substance use and mental health disorders of those we address are, of course, ever present in that particular group. We are currently serving approximately 150 participants in LEAD, with the goal of doubling that number in the next 12 to 18 months. Based on Snohomish County's experience, I am strongly recommending that the ongoing legislative fix to Blake promulgated through Senate Bill 5536 include funding for programming that encourages the active and responsible use of pre-booking diversion programs such as LEAD and AJA around the state. Thank you.
Thank you. Todd.
Thank you, Madam Chair, members of the committee. My name is Todd Morrell, and I am the Assistant Chief for the Burien Police Department, a contract partner with the King County Sheriff's Office. I'm here today to express support for key aspects of Senate Bill 5536, which reframes our approach to certain drug offenses. The Burien Police Department strongly supports pre-booking diversion, and we are pleased to see this bill encourages this philosophy. We recognize that the scale of drug problems in our communities is vast. Many of our residents' struggles with addiction cannot be remedied with traditional criminal justice metrics alone. The Burien Police Department would ask the committee to consider expanding their investment in LEAD and other community-based pre-booking alternatives, because we know from experience that traditional criminal justice methodologies are often not the most effective response in every circumstance. However, we also recognize that traditional methodologies must be an option for our officers within our comprehensive approach towards addressing drug offenses in our communities. Thank you for allowing me to present testimony in support of continued investment in pre-booking diversion programs.
Thank you for joining us this morning. Lisa?
Thank you. Good morning. I'm co-executive director of PDA. We provide project management and technical support for pre-booking diversion models such as law enforcement assisted diversion lead. I'm here in general support of Substitute Bill 5536 because it does preserve the ability of law enforcement and community members to respond to drug use issues prior to jail booking and without prosecution. I do want to pause to say that we are fortunate or not to have decades of evidence about whether the threat of serious criminal penalties will incentivize or accomplish people recovering? And the answer is generally no. It is generally unhelpful and interferes with people's ability to stabilize. That doesn't mean that police, courts, and prosecutors can't play a constructive role, but the key point is not to tie anyone's hands so that they have to do a thing that is not constructive. So if you could bear that principle in mind as you finalize this bill, I think that'll be incredibly valuable. The most important change you can make to the current bill that would build consensus.
Lisa, I'm going to give you a little extra time because you were helping to answer some questions.
Thank you so much.
Just a little.
Wrap up. The important change you can make to foster better outcomes and build consensus would be to expand investment in law enforcement assisted diversion under RCW 71-24-589 and expand WASPIC's Arrest and Jail Alternatives program under RCW 36-28A-450. This is an era of division, but on this topic, there's actually widespread agreement. We should all be on the same side, providing sustained care for people who use drugs to deal with physical and psychological pain. I'm grateful for the clear vision of many police, prosecutors, community leaders, civil rights leaders, formerly incarcerated people, and service providers that we need to do more, not less, but learn from the painful experience of many decades that in general, the solutions do not lie in the criminal punishment system. Thank you.
Thank you.
Hello, my name is Malika Lamont, and I'm the director of the Lead Washington State Technical Assistance Team and Vocal WA, and I'm the co-founder of a low-barrier buprenorphine clinic that is here in Olympia, Washington, that is housed in a peer-run licensed behavioral health facility. I'm here to express support for key aspects of Senate Bill 5536, which reframes our approach to certain drug crimes. I've already stated my personal relationship to LEAD, and we're glad to see that this bill encourages maximum use of pre-booking diversion. The scale of issues that our communities are facing is vast, and in continuing to prosecute people is not going to get us to the, in the manner that we currently are and have, will not solve these problems. We know that court-based responses aren't optimal for problems that stem from trauma, mental health, and physical health. Punishing people for physical dependence on a substance is not going to create the change that we want to see. I'm glad to see that substitute bills name lead and arrest or jail alternative programs as pre-booking diversion frameworks, but we need more funding for them. Budgets are policy. And I know that we're not supposed to focus on the policy issues in this particular meeting, but funding them will continue to create access for meaningful intervention in our communities. Thank you.
Thank you. We're not going to do questions. Up next is Don Julian online, and while we're waiting for him to come on, Chad Enright, Larry Jefferson, and James McMahon, why don't you come forward? And then after John online, I'm expecting Dan Templeman, Carolina Hershey, Gretchen McDevitt, and Sean Kelly. So Don, welcome. Don, try to unmute. All right, well, we're waiting for Don to find us. Chad, please go ahead.
Thank you. My name is Chad Enright. I am the Kitsap County Prosecutor. I am here on behalf of WAPA. I'm also a SERSAC member. I first want to say that I think this bill is a good start I have a couple of concerns. One of those concerns I think has been brought up earlier today, which is the crime lab and the issues with the crime lab. Case law essentially requires that we prove a controlled substance is in fact a controlled substance via a lab test. Lab has to prioritize cases based upon seriousness. Obviously, a felony is more serious than a gross misdemeanor. Right now, gross misdemeanor testings can take months, if not up to a year, to get done. If that is not resolved, if that remains a problem under this statute, the statute becomes essentially unenforceable. And so I really want to emphasize that for you folks, that that issue absolutely has to get resolved. Without the threat of prosecution, without that crime lab issue being taken care of, there is no threat of prosecution. And so what we're seeing from, you heard from those mayors, more and more cities are passing local ordinances. We're going to end up with a patchwork of different laws across the state. And I don't think anybody wants that.
Thank you. Let's see. Don Julian, I believe you're with us. Can you hear us?
Yes, I can hear you.
All
Can
right.
you hear me?
Yeah, welcome.
Hi. Thank you. I seem to be having a problem with my camera, but I just wanted to have a little different view, which is the CSRSAC committee voted on decriminalizing simple drug possession totally, and I agree with that view. That's the only thing that really differ with a lot of people on is that I don't think you need a carrot and a stick. I think you need more opportunities for early intervention with easily accessible care that people want. When you disrupt someone's life, it adds more burdens and more problems in the long run with life, job, every aspect. People lose their kids. I was personally affected and went into prison, and it was a lot more trauma than anything else I've ever done. But I encourage to think about a new approach that's more compassionate and more available, more helping. That's all I got to say today. Thank you.
Great. Thank you very much for joining us. Senator Mellon, we are not asking questions of people. Nope. We are not asking, we already asked our questions. Oh, I see. From our capital budget chair, a report on the crime lab. Mark.
Yeah, Chad, I think your comments are well taken. I think in the capital budget that gets released next month will make the largest investments we've probably ever seen in that crime lab space for all the reasons I think that you highlighted in your testimony. So I think that we appreciate that comment.
Thank you.
Okay, thank you. Next up is Larry Jefferson.
Good morning. My name's Larry Jefferson. I'm the Director of Public Defense for the state of Washington, and it's a pleasure to be here this morning. I want you to take the bold step and learn something from the 50 years of war on drugs, and that is that we need to decriminalize. We can't coerce people into treatment. We should take advantage of our laws that we have to allow us to involuntarily commit people if they have drug problems. We should use our lead. Also getting to the point of the financial costs. Right now, if you criminalize, fully fund public defense, fully fund it all over the state, especially in your municipal courts. Right now, we have part-time public defenders, part-time judges, and part-time prosecutors. If you're going to do this, give them the money, but also provide the treatment to do so. I heard some stats on before Blake, there was 9,000 people who got drug offenses. Only 3% of them got into a drug court. So to think that we're going to get 50% of this pretrial population at 50% of the 12,000 cases that I heard, that would be like if Jesus showed up and happened. And the other thing is you're going to need to fund the lab, because I, as a defense attorney, is going to demand that information on every single one of these cases, and that's going to slow them down. I'm going to slow you down. You don't want to give this to, we don't want to make employment for attorneys, and this is what recriminalization does. I don't want to, I already need 70 attorneys across the state of Washington right now. And so we're going to increase that caseload.
Larry, I need you to conclude. And
I know. I'll just say one more.
The threat of more attorneys is going to cause me to cut off your microphone.
I know. Yes. One more thing. There's a national ABA study on caseloads involving public defenders, and it's going to recommend that all public defenders get less of a caseload than they have right now, and that's going to have really big implications. Thank you.
Thank you very much. Points taken. Next up is Dan Templeman.
Good morning, Madam Chair and members of the committee. For the record, my name is Dan Templeman, and I'm the police chief for the city of Everett, and I'm here today to testify in support of Substitute Senate Bill 5536. I want to start by thanking Senator Robinson for her willingness to draft a bill that seeks to address what has turned into a public health and public safety crisis on our streets. While this bill contains some positive elements, I remain hopeful that as it works its way through the legislative process, that the committee will consider changes as it relates to post-conviction deferral and treatment versus the offer of pretrial diversion. From our perspective, we are looking for solutions that will have the greatest impact on public health and safety and give those suffering from substance abuse disorder the best opportunity for recovery. As you consider the fiscal impacts of 5536, it's important to recognize the increased costs for cities, particularly as it relates to prosecution in municipal courts. Historically, these superior courts and district courts have been funded by the state. However, it's imperative that we acknowledge the need to fund these new costs at the local level. Senate Bill 5536 represents an improvement over where we're at today. We have a great opportunity with this bill to make a meaningful impact to those experiencing substance use disorder. But to be effective, this bill must not only properly fund at all levels, but also create the incentives necessary for someone to seek treatment over jail time, which is why I hope you will consider future amendments. Thank you for the opportunity to testify.
Thank you. Carolina Hershey.
Good morning, Madam Chair and committee members. My name is Carolina Hershey, and I'm a peer case manager with the Olympia Arrest and Jail Alternatives Program. I'm here to speak in support of key aspects of Senate Bill 5536, specifically pre-booking diversion programs. As a case manager for Arrest and Jail Alternatives, I see that my participants' mental health and basic needs are met while they maintain accountability daily using my lived experience with substance use and mental health. This is a service I was not afforded prior to becoming a burden on our justice system, but would have greatly benefited from. The scale of drug problems in our community is vast, and for costs alone, courts will not be able to address more than a small fraction of them. I'm also glad to see that the bill names lead and arrest and jail alternatives programs as frameworks for pre-booking diversion. These frameworks are well established and respected. The Arrested Jail Alternatives Program of Olympia is revered among local law enforcement, community providers, and participants alike. I ask that existing lead and AJA programs are expanded so they may scale and more jurisdictions can start this work. In closing, our services assist the court system by freeing up already limited resources. Programs like Arrest and Jail Alternatives and LEAD are ready to address this public health concern on the front lines if given the tools to succeed. Thank you very much.
Thank you. James McMahon.
Good morning and happy Saturday, Madam Chair and members of the committee. I'm James McMahon, Policy Director with the Association of Sheriffs and Police Chiefs. We appreciate Senator Robinson, Senator Dingret, and the Senate's leadership, quite frankly, on this must-pass priority for us this year. As you all are aware, absent legislation being enacted this year, drugs become legal in Washington on July 1st of this year. Our experiment with the effective legalization of drugs has failed in our view. Our prisons were never filled with simple possession-only cases, but now our public spaces feel like they are. It is neither compassionate nor humane to leave those with a substance use disorder to their own devices and require a law enforcement officer to stand by and do nothing. We testified in support of this bill when it was in the policy committee, but we are concerned with the direction that the substitute bill has taken. We will send you a letter later today with our specific recommended changes to the bill, but I'll conclude with the fact that we support prevention, we support treatment, and we support leveraging the consequences of the criminal justice system to encourage those to get treatment.
Thank you. Gretchen McDevitt.
Hi. The bill has many excellent provisions which I support, but I signed in con because the substitute bill weakened the original bill. I know something about addictions. I'm a retired high school counselor, have served on a mental health board, and have had family members with addictions and have seen the devastations they cause. The original bill was great, but the substitute bill added knowing possession rather than just leaving it possession, severely weakened the bill and the incentive for drug addicts to get help. Quote, I borrowed this jacket from my friend. I didn't realize there were drugs in it. It is only a gross misdemeanor, so is law enforcement going to have the time to prove the subject really did know? Proponents of treatment-only options say this is a public health problem, not a justice problem, and should only deal with treatment. But that is not true. It is both, because too many crimes have been committed to get money to buy drugs. Every day on Next Door Neighbor website in my community, I see car break-ins, catalytic converters stolen, strangers opening gates to backyards looking for stuff to sell and scaring people so we don't even feel safe in our homes. If you are determined to leave knowing possession in the bill, at least add something like knowing possession or should have known, or define knowing possession to include situations like if a person has the drug on them, that should be knowing possession. Thank you very much.
Thank you. Mayor Kelly.
Good morning, Madam Chair and members of the committee, and especially Senator Mullet from the 5th. The City of Maple Valley City Council supports 5536, but one of the things we really want to emphasize is funding for additional resources, i.e. prosecutors, courts, and stuff like that. It's going to put a lot more burden. Our budgets in the cities are really tight, extremely tight right now, so this is going to put more on our court system. So we really want to make sure that we get more funding for that if we move these forward. So again, the City of Maple Valley supports this, support everything the previous mayors have said, and we are willing to work with you on anything you need help with or more information. Our police chief is willing to come down and talk to you about this, and we just want to be partners on this when we're making sure that our citizens feel safe, welcome, and involved in our communities, especially with the summer events coming up. We got to make sure that everybody feels welcome, but we also have resources for people who are going through hard times. Thank you very much for allowing me to speak today.
Thank you, Mayor. In person to testify, I'd like to call up Adon Espino and Michael Transu. And is that it?
Do we have?
Oh, that's it.
We just had the mayor.
We just had, yeah. All right. You two are wrapping it up for us.
Oh, boy. Go ahead. Well, good morning, Chair Rolfes, members of the committee. My name is Adon Espino, and I'm here on behalf of the Washington Defender Association and the Washington Association of Criminal Defense Lawyers with some concerns still on Senate Bill 5536. But we do greatly appreciate and support the bill's move toward supporting additional treatment avenues. This is the right path, but it is in that vein that we continue to oppose recriminalization of drug possession. I mean, outside of the good policy reasons to not recriminalize, there will be a significant fiscal impact that's not noted in the fiscal note through the cost of providing constitutionally guaranteed defense of every person tried for criminal drug possession. The current fiscal note estimates that there will be 12,000 cases of misdemeanor drug possession. At 12,000 cases, the system will require significantly more public defense. Misdemeanor caseload standards for public defenders are 300 cases per lawyer. So if you do the math, it's 40 additional lawyers plus their support staff, including investigators and social workers. And I will conclude there.
Thank you.
Great. Thank you, Madam Chair, Madam Ranking Member, and members of the committee. My name is Michael Transu, and I'm here today testifying on behalf of about 3,500 members of the Washington State Fraternal Order of Police. We support Senate Bill 5536 for the following reasons. As you've heard, it allows prosecutorial and law enforcement pre-charging diversion programs, like alternative programs to jail and law enforcement assisted diversion programs. It establishes a knowingly possession of a controlled substance standard in state law. As Chad Edenwright mentioned, it does exempt substance analyzation and testing equipment. Thank you, Senator Mullet, for funding that in the capital budget. Thank you, Madam Chair, and especially Senators Robinson and Dingra for your work and the balance of the interests that are impacted in this legislation. We think it does a really good job of balancing accountability, treatment, and consequences. If we had one ask, it would be that the body consider a stronger emphasis on the incentives to treatment. And thank you, Madam Chair, and happy to answer any questions.
Thank you. Thank you for wrapping us up, Michael.
Yeah.
That concludes our public hearing on substitute Senate Bill 5336. I want to thank everyone who participated and thank you to the committee members. This is one of our more complicated and important bills.